With that, we will hear first from the government. Thank you, Judge. Ladies and gentlemen, first of all, I want to thank you for your time and your attention. We all recognize what a burden and a sacrifice it has been for you all to have been here for the last now going on 3 weeks. So let me start with just a thank you for your time, attention, and your sacrifice for being here and serving as jurors. I would like to start out, you've heard the indictment read to you at the beginning of the trial, and that was 3 weeks ago. But that's ultimately what you have to decide, is whether or not we have met our burden of proof as the elements of the various crimes that we have charged in this indictment. So the first part of my closing argument now, I want to speak to what the charges are, what the elements are that you will have to consider. You are going to hear more of this from the judge when we are all finished arguing. But I think now is the appropriate time to go over who's charged with what and what those elements are so that you can start factoring the evidence that you have heard over the last 2.5 weeks with the crimes that we have charged. Count 1 is the RICO conspiracy. At the top you will see we have listed the charged defendants, Telly Hankton, Kevin Jackson, and Walter Porter. Very simply, a conspiracy is an agreement. What we have to prove is that 2 or more people agreed to commit a RICO offense and that they knew and agreed to the object of the RICO offense. Certain racketeering offenses as they apply in this case are drug trafficking, murder, attempted murder, and bribery. So the next question is, what is a RICO offense? Well, the first thing that has to be established is that there's an enterprise. Now, that's a legal term. What it really means, and the judge will give you more information and definitions to this, it's a group of individuals associated, in fact. Now, it could be something as formal as a corporation, but it could be something as informal as 2 or 3 or 4 people getting together to have a common objective. An informal association of individuals can constitute an enterprise. The enterprise has to affect interstate commerce. You have testimony about drugs moving from Texas to Louisiana. You have heard testimony about guns that are manufactured outside of the state of Louisiana brought into the state of Louisiana. That's the interstate commerce element we are talking about. We have to show that the defendants associated with the enterprise. What does associated mean? It means a loose relationship as a partner, a friend, an ally, a cousin. We have heard plenty of testimony about that. Family. Did they associate with one another? Did they participate in the affairs of the enterprise? Well, the enterprise that we have charged as to this Hankton drug trafficking organization is drugs and murder, attempted murder, bribery, to facilitate, to enforce, to control their objective, selling drugs on Josephine Street. Finally, were at least 2 acts of racketeering activity accomplished or conducted during the course of the RICO conspiracy: drug trafficking, murder, attempted murder, bribery. The second count is a drug conspiracy count. Much like the RICO conspiracy count, you have some of the same elements here. 2 or more people have to agree to distribute controlled substances. Every person that joined the drug conspiracy, did they know of the unlawful purpose of the agreement? Did they join it for the purpose of selling drugs? That's illegal. That's an illegal conspiracy. Did they do it willfully? Did they purposefully? Did they voluntarily? Did they knowingly join the conspiracy to sell drugs? If you find those first 3 elements, you are going to see on your jury verdict form, when you go back to deliberate later today, some questions particular to the different types of drugs that you have heard discussed during the trial. Cocaine base is the federal term for crack cocaine. That's what cocaine base is. Cocaine hydrochloride is the powder cocaine such as the kilos that Adrian Mosley was distributing and supplying to the Dillons and Telly Hankton. Heroin, marijuana. You'll see some particular questions when you go back to deliberate as to the amounts of drugs that you found that was proven if you find the drug conspiracy was otherwise proved. The gun conspiracy, all 4 defendants are charged in this count. In the previous count, the drug conspiracy count, only Telly Hankton and Kevin Jackson are charged. In the gun conspiracy count, all 4 defendants. Again, it's another conspiracy count. 2 or more people coming together to agree to accomplish some unlawful purpose. Here it pertains to the weapons that we have brought before you. Did 2 or more people agree to either use and carry firearms in relation to the RICO conspiracy or the drug conspiracy, or did they possess the firearms in furtherance of the conspiracy? Did they each know of the unlawful purpose of the agreement, similar to the drugs that I just told you about, knowingly using guns to facilitate what they were trying to accomplish, and did they join it willfully? So those are the 3 conspiracy counts that override sort of the whole case. The RICO conspiracy, which pertains to the enterprise at Josephine Street, the drug conspiracy, the selling of drugs on Josephine Street, and the gun conspiracy, the using of those guns to enforce their objective to control Josephine Street. Here count 4 is a conspiracy to obstruct justice, but this really only applies to Walter Porter. It pertains and results from that June 23, 2007 arrest of Cornell Evans, Brian Hayes, and Gerard Howard. You heard evidence of Walter Porter's efforts to try and help his friends Brian Hayes and Gerard Howard by attempting to get Cornell Evans to take the charge because he didn't have a felony conviction. So the elements as to count 4. Did he and at least one other person reach an agreement to try and corruptly influence, impede? I'm skipping a few of the elements, but you will see them there, and you will have them when the judge talks to you. To have Cornell Evans falsely claim possession of a firearm? Did he know of the purpose? Did he join it and try to further it of his own accord? Now we get to the murder charges. You are going to see as to each of the murder charges. Darvin Bessie, counts 5 and 6. Darnell Stewart, 7 and 8. Jesse Reed, 10 and 11. Hassan Williams, 12 and 13. Curtis Matthews, 17 and 18. The individual act of murder for each one of these victims is charged 2 different ways. 2 different statutes, essentially, were violated by that murder. That's what we have charged in our indictment. So it's the same act. It's the same killing of Bessie, Stewart, Reed, Williams, or Matthews, but it violates 2 different statutes. You see the defendants charged as to each one. So counts 5, 7, 10, 12, and 17 are one way each murder was charged. Murder in aid of racketeering. Telly Hankton charged as to Bessie. Telly and Andre charged as to Darnell Stewart. Telly, Walter, and Kevin as to Jesse Reed. And Walter Porter alone as to Hassan Williams and Curtis Matthews. You are going to see some of the similar type of elements that I just went over as to what constitutes a racketeering offense. There has to be an enterprise, engaged in interstate commerce activity, engaged in racketeering activity, and that a murder was committed for one of 2 reasons, either for money or something of value. You heard plenty of evidence about that with regards to Walter Porter, or that it was done with the motivation to maintain or increase position within the enterprise. Were these murders done to help control Josephine Street, to help settle the feud, end the feud, finish the feud so that the Hanktons could continue to deal drugs on Josephine Street, so Telly Hankton could maintain or increase his position with regards to drug sales in that Central City neighborhood? The state law definition of murder is tied to murder in aid of racketeering charges. Second-degree murder under Louisiana law is the specific intent to kill or inflict great bodily harm. When you are standing over somebody, pumping them repeatedly with bullets, I would submit that you have the specific intent to kill or inflict great bodily harm. You are also going to hear a charge from the judge in aiding and abetting. I'm going to talk to you a little bit more about that in a moment. That, in essence, is when 2 or more people work in concert, work together to accomplish a goal. Both people are responsible for the efforts of one another. You are going to see a little bit more about that in a moment. The other way murder is charged, again, 6, 8, 11, 13, and 18 are those same murder victims. This is just the alternative statute that's violated by this murder, and it's murder in furtherance of the RICO and drug conspiracies. We have to show that there was a violation of either a RICO or drug conspiracy, that the defendant used or carried a firearm during and in relation to the murder in furtherance of either of those counts, that they caused the death of the victim that applies to each count, that the killing is a murder as defined by federal law, that is, it was done with malice aforethought. Did he have intent to kill the person? It wasn't an accident. It was purposeful. He meant to do it. Finally, aiding and abetting applies as well to these murders. All right, so what's aiding and abetting? I'm going to give you what I submit is a sort of classic definition of aiding and abetting. Here's the language of it. The judge is going to give you more instructions on this later this afternoon, but a classic definition of it, I would submit, is when 2 people agree to go commit a bank robbery. I'm going to take it out of our facts here for a moment. You have the person that goes into the bank with the gun or the note, and you have the getaway driver. The getaway driver knows that the man who went inside is going to commit the bank robbery. They have set up their system, their method for robbing the bank. They have the getaway driver with the engine going and ready to go so they can make their quick getaway. The getaway driver is just as responsible for the bank robbery as the guy who went in with the gun. So that is what I would submit as an example of aiding and abetting. The guilt of a defendant in a criminal case may be established without proof that he personally did every act constituting the offense alleged. It recognizes that anything a person can do for himself may be accomplished by him through the direction of another person or his agent, by acting in concert with or under the direction of another person. If another person acts under the direction, or if the defendant joins another person and performs the acts with the intent to commit the crime, the law holds the defendant responsible for the acts and conduct of such other persons as though he committed the acts himself. He must deliberately associate. He must know that they are going to rob a bank. There are elements to aiding and abetting, and now bring it back to our case. That there was an offense of murder or a shooting committed by one person, that the defendant who didn't do the shooting nonetheless associated himself with the criminal venture. He actively participated in the criminal venture with the advanced knowledge of the use of a firearm, and the defendant sought by the action to make the venture successful. Counts 15 and 16 are very similar to the murder counts, but they apply to John Matthews' shooting. He wasn't killed, obviously. He was there to testify before you. These two counts, 15 and 16, apply to the shooting of John Matthews. Two different statutes violated, charged because both statutes were violated, very similar to the murder. Just substitute the fact that there was a shooting instead of a killing. He was obviously shot, as you heard from him, 17 or more times. All of the elements are essentially the same, just substituting attempted murder or the shooting of John Matthews as opposed to the murder of John Matthews. Count 16 is very similar to the alternative way we charge the murders where they used the gun in furtherance of the RICO conspiracy or the drug conspiracy. It's just John Matthews wasn't killed, but they discharged the weapon, obviously, by shooting him. Walter Porter did. Aiding and abetting applies here as well. Count 9. This applies to Telly Hankton's sawed-off shotgun taken during the traffic stop. I don't know if you are going to hear much dispute as to this, but these are the elements that apply to this sawed-off shotgun. 1. That he possessed it. You will hear about constructive possession and actual possession. If you have control over something that's in your car that you're operating and you know about it being in your car, you have constructive possession of what's in your car. But it's under your dominion and control. You control, you possess what's in your car. The barrel is less than 18 inches. You heard from Tom Ross, the ATF agent, who measured it and said it was approximately, 13.5 inches, well under 18. He knew of it. It was operable. You heard that it was test fired, and that it was not registered with the ATF. There was a stipulation at the beginning of the case, on the very first day of the case, but I want to remind you of it, where there was no dispute. Telly Hankton and the government agreed that he didn't register the gun with the ATF, so that element is really not in dispute. The last 3 counts are possession of a firearm by a convicted felon. These apply to Walter Porter. There was a stipulation at the beginning of the case that Walter Porter is a convicted felon, which makes him ineligible to possess firearms. The elements otherwise are that he possessed the firearm, he is a convicted felon, and that the firearm traveled in interstate commerce. These result from 2 different sets of evidence that you have heard during the case. You heard from Gerard Fedison about getting arrested and giving Walter Porter some guns right before the police arrested him, and Walter Porter made off without some guns. That's count 14. Then counts 21 and 22 as to Walter Porter are the Romarm assault rifle that was recovered during the search warrant at South Liberty during the Curtis Matthews investigation, and the pistol that was recovered from his Oldsmobile Aurora during the search warrant during the Curtis Matthews investigation. That's count 21 and 22. Apply those to guns. I'm going to take you back. Now at this point, I want to take you through what our evidence has been in this case.